Well, let's start off with the moral of the story for this a little bit, okay? So we're going to go through a Superior Court decision, which is recent, RVJA 2025 ONSC 4531. It's an Ontario Court, a Superior Court decision. Very well written.
Just came out on
Justice
on the
Bordin,
10th.
Bordin. Very well written, but I have to tell you, no one should use Snap, eh?
Yeah, so
Snapchat.
this has to do with message exchanges. And so we have a number of cases that come up where people use Snapchat, and it's primarily seen as nefarious because the whole system is designed to auto-delete.
Yeah.
So it was like, why would you want to delete your conversations? And then, of course, it partially deletes things. And so when you go back and try to recover things, you're missing messages in there, which then could be held against you because you're missing messages. It's just an absurd platform to use in a world where...
Well, there's a lot of platforms like that because you want secrecy. But the reality is, there's a real moral of the story here because this is an interesting case, and it just does. There's tons of messaging between these two young people, an 18-year-old, a 17-year-old. He's accused of sexually assaulting her. They were boyfriend, girlfriend. They have heated discussions via text, and there's tons of text messages, which is stuff we're used to. And the judge does a really good job of doing an analysis of the text messages, and I think it's a great example because we've talked about this before. And this is, when we talked about having an interest in text messages and trying to exclude text messages don't help, this is certainly a case where there are plenty of text messages introduced at evidence, and the Crown wanted to use that the lack of response and other responses were an admission of guilt.
So yeah, this primarily deals with a situation in which an accused person is directly being confronted with the allegation on text messages, and whether or not they say, that never happened. Right,
on a couple of exchanges said, you raped me, or rape 20, 30 times.
Rape.
Right.
And the person just goes, hey, it's snowing out here today.
No, they didn't do that. In fact, the judge did a great job of the analysis, and I think it's important just to review so people understand just how text messages can be a real issue.
In this situation.
Well, who are these people?
So there's two young people who had a confrontation after a sexual encounter in which
an 18-year-old male, 17-year-old female, they're dating.
The complainant went to the bathroom at one point, and the accused went into her cell phone, apparently guessed her password. It's not my birthday, it's my birthday backwards.
Yeah.
Guessed her password and started looking at I got that line.
Well, there's a British comedian.
I got that line from a show, actually.
There's a British comedian who does a really good job about passwords and how we all basically did the same thing about passwords, but I won't go into it. It's a great one, but
I've been watching this series, which is so stupid. I actually thought, why am I watching this? But it's so funny that I kept watching it. It's called Ghosts. and one of the ghosts can actually touch stuff and uses her cell phone to send messages. And she goes, I changed my password. And they go, is it your birthday? And she goes, no. Is it your birthday backwards? And she goes, damn you. Anyways, so you should watch Ghosts because it's really funny. So in this case, she went to the bathroom, he accessed her cell phone, and then found out that discovered that she was cheating on him.
Right.
And then there's a series of messages exchanged between the two of them where she's begging him to talk to her and desperate to see him again and really upset that he's cut her off and he's angry with her. And none of which is contained in her statement. She presents a different scenario. And then she ends up accusing him of sexual assault. And so then the messages in question are ones that come after this whole exchange of her saying, please talk to me, please talk to me. And so there's a little bit of context as to why the judge perceived the messages and his lack of denial later, including that he testified that there were actual phone calls.
Right, which you would expect sometimes.
There were actual phone calls in which he says...
And she was denying that they had phone calls.
She denied that they had phone calls. And he's saying, no, there were phone calls. And I think that the judge was really affected by the evidence of her persistence in trying to continue contact and reconnect with him.
But he did not find that there was admissions. We'll have to go through it. I think it's important. So,
yeah, so
she alleges...
There's a difference between admitting something where you apologize not necessarily an admission of guilt, but you can apologize to somebody because you feel bad that they're upset, right? So we've had a number of cases that we've won where a person actually said, I'm really sorry, but that apology didn't actually amount to an admission of guilt. But in this case, it wasn't even an I'm sorry. It was just the fact that when he was accused of sexually assaulting her, he didn't say, that's not true.
No, but he said other things. I mean, the judge does a good job. Look, there's a lot. Like, let me just set it up a little bit. Yeah. So she alleges when she woke up in the morning, she was penetrated vaginally. She accused him of rape. The Crown's position was that he took the opportunity when HM, the complainant, went to the bathroom after the sex assault to search her phone to find something he could use against her to counter the rape allegation and prevent her from reporting the sexual assault, and came up with the idea to accuse her of cheating. And I think this also involves a capacity to consent issue. The defense theory was different. They had sex after prom night. They stopped because it was physically discomforting to her.
Cheating, looking at what paragraph you're on.
I'm just on 5. Oh. Then while HM was in the bathroom, he looked at her phone and found evidence that she was cheating on him. He says that they were dating at the time. He confronted her with the allegation of cheating, and then she accused him of rape to prevent him from telling people that she cheated. Both of them plausible, right? And the court, I just want to say this at the outset, because in a podcast from last week, I'm a little critical about the Supreme Court of Canada, how they lay out consent at capacity. And this judge does a lovely job of just setting it out so
Quotable
nicely
quotes.
And clearly. It says consent is subjective. It requires the complainant to formulate a conscious agreement in their own mind to engage in sexual activity in question. The relevant period of time for consent is while the touching is occurring. A complainant does not have to express lack of consent or revocation of consent for the actus reus to be established. No consent is obtained if the complainant is incapable of consenting to the sexual activity. A complainant will only be capable of consenting if she has an operating mind, able to understand a physical act, that the act is sexual in nature, the identity of the participants, and that she has the choice to refuse to participate. If the Crown proves the absence of any of these factors beyond a reasonable doubt, then the complainant is incapable of subjective consent, and the absence of consent is established at the actus reus stage. Oh, so nicely laid out. Yeah. And then refers to the criminal code and all this. Of course, the individual must be conscious throughout the sexual activity. Of course, if the complainant's asleep, they're not conscious and cannot consent. That's a shame. I'm just kidding. A complainant's evidence that she did not consent is a matter of credibility to be weighed in light of all the evidence, including the complainant's words and actions before and during the incident, and by reference to the totality of the evidence, including any ambiguous or contradictory conduct by the complainant. And correctly quotes paragraph 50, citing 𝐕𝐈𝐃, paragraphs 29 and 61. In addition, the evidence of other witnesses, including the accused, about the totality of the complainant's conduct, I like this one, can be considered to determine whether...
Slow it down. Slow it down, Joseph.
In addition, the evidence of other witnesses, including the accused, about the totality of the complainant's conduct can be considered to determine whether it is consistent with the complainant's claim of non-consent. SB at paragraph 50, citing 𝐕𝐈𝐃. The same is true about the complainant's evidence that she was asleep. However, what the accused thought about the complainant's state of mind is irrelevant. Nobody really cares about that. It's only relevant when the defense of honest but mistaken belief in communicated consent is raised in the mens rea stage of the inquiry. Good. You put that in there to do a complete analysis. But they made it clear. The evidence of other witnesses, including the accused, about the totality of the complainant's conduct can be considered to determine whether it's consistent with the complainant's claim of non-consent, because it's a matter of credibility. Yeah. And they don't get into stupidity about it's direct evidence, it's circumstantial evidence. They just state it very clearly.
And to be clear, because you mentioned it, you referenced this recent Supreme Court case that was issued on November 7th of 2025. That was RV Rio 2025 SEC 34. And this decision was rendered on the 10th of November, so only 3 days later, and it wouldn't have had the benefit of reading the Rio decision at the point of crafting this decision. Or
being confused by it. So
yeah,
I just want to focus on there is no adoptive admission by JA, which is the accused. So that's what the judge concludes at the end of the analysis. Mm-hmm. And it's really good. But I just want to go through a little bit of the law as a refresher on text messages. I'm at paragraph 63. Do you want to read from there?
Well,
Or do you
you're
want me
at
to do it?
63?
Yeah.
Because I just wanted to mention something briefly from paragraphs 25 to 26, which says that JA and HM, the accused and complainant, they both said that they loved each other before and after the night of the prom, the incident, and both HM and JA described their relationship as toxic. The allegations of cheating and the nature of the relationship between HM and JA is not relevant to whether or not HM consented, was more likely to consent, or less worthy of belief. The evidence is important context to assess the evidence of JA and HM and the communications between them.
Right.
And this is why we talk about, like, these cases are not generic. They're very case specific. And in this case, there's a lot of messages not related to the allegations being presented to him and his failure to confront her and say, you're lying about this never happened, that there were a lot of other communications that the judge had to take into consideration.
And he did because he wanted to understand their dynamic, how they relate, how they speak to each other, because text messages are sometimes a bit difficult to read tone and meaning into.
Cheat, what paragraph?
63.
I still had stuff at 37. But
Go ahead.
all right.
Go ahead. There's some good stuff here that I just want to read about.
Paragraph 37, JA denies that HM said that he raped her before she went into the bathroom. And next paragraph, he guessed her password, got into her phone. I kind of covered this. And found things that established in his mind that she'd been cheating on him, including explicit photos.
Right.
He explained his reasons for checking her phone in various ways. He said he had a gut feeling or intuition that she was doing something behind his back, but he had no evidence, and he was also curious. Opportunity compelled him. So can we talk about this for a moment? Like, what's the consequences of going into somebody's phone without permission? He didn't have the actual messages, but he could testify about it.
Yeah, nothing. Like, there's no, I mean, you know, it's not nice. It's a breach of trust. It's a breach of privacy, but it's not a mischief to data offense.
As soon as I asked that question, I thought, why did I ask that question? Is because we have a number of cases where somebody forcibly takes somebody's phone to go into their messages.
Well,
that's very different.
Yeah, it's a bit different. I mean, look, he didn't do it with her permission. She was in the washroom or she's sleeping, whatever it is. But, obviously he had some concerns. He looked. It's not a great thing to do. It's an invasion of privacy. She's entitled to her privacy like anybody else is. But, whatever. I mean, these are two people in a relationship. You presume it's trusting and caring. And he felt there was something awry. So it's, it's an ungentlemanly thing to do, but he did it. Yeah. But it's not a mischief to data. He didn't steal the data. He didn't corrupt the data.
He didn't even screenshot it or send it to himself. Yeah.
He just confronted her with it afterward, which, how many people do to each other in relationships all the time?
There's an important point with text messages. You can testify about what you saw in text messages without having the actual messages.
Yeah.
And that's so intriguing because when you have the actual text messages, what do we have to do?
Well, we have to bring a motion.
We have to bring a pretrial motion.
Because the records are in our possession.
Yeah. So if we want to present the actual text messages, now we have to go through a whole new process to get permission to use them. Meanwhile, he can testify about them.
Yeah. Duh.
I'm so stood out in my mind as an interesting factor.
No, I agree.
Okay, I'm catching up with you. You're on 63?
Okay, 63. So the parties agreed that the text messages which were made exhibits are not to be used as prior consistent statements to enhance the credibility of either JA or HM because of the repetition of the allegations contained in the text. That's good law.
So, and that's similar to what we call similar, or prior consistent statements.
Right. The text messages may, however, be used to assess the credibility of JA and HM, particularly with respect to the context in which the allegation of sexual assault arose and the sequence of events from the alleged offense to the charges. They may be used to understand HM and JA's conduct and assess their truthfulness, or assess if there is evidence of a motive to lie. And they rely on Langan, Langan, 2019, BCCA.
That case breaks my heart.
Sorry?
That case breaks my heart.
I know.
I know, because another case came out which they should have won based on the new decision. Anyway.
And it went to the Supreme Court of Canada, so it's 2020 SCC 33. It is the Crown's position that JA's responses to the rape allegations in the text messages constitute an express admission of having sexually assaulted HM, or at the best, equivocal denials where it is reasonable for JA to respond to HM's allegations and it would have been simple to do so.
And again, it's important for people who go to 𝐂𝐏, and I encourage you to do so, to understand a lot of these cases. But it's important to understand this is a summary of the Crown's position. This is not a summary of what the judge is finding.
No, but it's got to do a setup. And so the accused position is that he denied the rape allegation on the phone and in person, and that his text messages do not respond to the allegation. He submits that an inference of adoption should not be made. An admission made, so this is important, an admission may be implied from a party's silence in the face of statements made by others in circumstances where the party could reasonably have been expected to respond. Okay, R.V. Beauchamp, 2015 ONCA 260. A statement made by another in the presence of the accused is only admissible against him in circumstances where he expressly adopts the statement or where by his words, action, conduct, or demeanor, he may be taken to have adopted.
So break that down a little bit.
A statement made by another in the presence of the accused is only admissible against him in circumstances where he expressly adopts the statement or whereby his words, action, conduct, or demeanor, he may be taken to have adopted it.
And
so a third party could say, you raped my sister.
Sorry, I didn't mean to.
If you put it that way.
Right? That would be an adoption. If you said, oh, sorry, I didn't mean to do that. A
statement against interest made to a third party about the allegation can be used.
But if you just said, I'm sorry, the I'm sorry could actually mean, I'm sorry that you're angry with me.
So I like that. So as stated recently in the case of R.V. Gordon, 2022 ONCA 799, boy, we're full of case law on this one. An inference of adoption may be available based on a person's words, actions, conduct, or demeanor in response to a statement made by another person and heard by the person whose response is being considered. Silence in the face of the statement made by others or an equivocal or evasive denial may also constitute an adoptive admission where the circumstances give rise to a reasonable expectation of reply. Adoption by silence must be approached with caution. Not all people respond alike. An accused's reaction to statements about him may have different meaning. Responses, including silence, may be ambiguous. All relevant circumstances should be considered, including the social context. Where appropriate, other explanations may be considered. See Gordon at paragraph 47, 53 to 55. This is very important.
Yeah.
This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record. And now back to our podcast. Thank you.
Because I'd like to point out, we actually have a case, or had a case in which...
We've had a couple.
Yeah, we've had a few. In which there's a recording of somebody being accused of something. And they said, if you don't answer, honestly, I'm going to hit you. And then there's audio that sounds exactly like the person being punched.
Right.
And everything the person says after that moment doesn't matter.
That's right. But what the court is emphasizing is all the facts have to be considered, including the context. So there could be a lot of factors at play. And we've had it in many cases where an accused will say, when they're faced with an allegation from somebody and they're just coming at them, they'll go,
I'm going to destroy your life if you don't...
I'm sorry. I'm sorry. I certainly never meant to hurt you. And the accused's explanation at trial is, look, this wasn't going well. What am I supposed to do? Get into an argument with the person? I didn't want to delegitimate what they were saying, but I certainly wanted to de-escalate because I got fucking terrified. This person could have ruined my life at the school, could have got me kicked out of university, could have done X, Y, and Z. There can be an explanation why you apologize or try and bring down the conflict. And there's a lot of also, social factors, contextual factors, cultural factors.
Shock. When somebody's accused
Absolutely
of
right.
something they didn't do, there's a bit of shock too. It's just like going, oh, I'm terrified. I don't know how to respond. And like in this case, they said there was actually phone conversations.
Well, and good for the judge. After considering all of the evidence, including the messages, The judge found that, in fact, J.A. spoke on the phone on June 9th and 10th and spoke in person the following week. So it wasn't accepted, as the complaint said, that they didn't speak about it. Right. And he accepted, and J.A. admitted that he was concerned about the rape allegations. He said he denied raping H.M. during their in-person conversations. He admits there's no text where he immediately responds to a text from H.M. that he raped her, in which he says, "I did not rape you." He acknowledged that. In hindsight, his responses and his decision to ignore messages alleging rape could be interpreted in a negative light.
In context, he was going at her hardcore about cheating on him.
Hardcore.
And, so then this rape allegation that he hears over text comes after she's been, not dealing with, the issue of her cheating on him and begging him to meet with her and stuff like that.
And there's tons of messages.
There's a lot of reason why
there's
he wouldn't
apologizing.
take it seriously.
There's apologizing, and here's this, but he's saying, I was apologizing for hurting her during intercourse, not that I was apologizing for non-consensual sex.
So to give context to that, he acknowledges that they were having intercourse and he stopped because she said, ow, or something like that. So he stopped immediately. So when he does give some sort of an apology, it was in regards to, I'm sorry that, we had to stop because obviously something I did was wrong.
Now, here's kudos to the judge. I want to say this because context is vital. The messages are part of a long chain of text messages and cannot be considered in isolation. The evidence clearly establishes that HM and JA argued a lot. The text messages capture adolescent obsession, passion, and single-mindedness. They were exchanged during a very emotional and heated time for the two young people. It's clear from the messages that in many instances, both immediately responded, leaving little to no time for reflection, careful thought, or phrasing. It can be difficult to understand or perceive tone and intention in text messages. Text messages are often terse, and when sent quickly can overlap with each other such that it appears people are not responding to the last message received. It can be difficult to fully understand the texter's intentions. Yeah. Yes, and yes. So it's a great example.
Another case in the past that talked about the complications of text messages, especially that overlap. Yeah. And this is a really good current reinforcement of that, especially when you're dealing with young people who seriously text so much, I don't know how they get anything done all day.
And the judge said, hearing the oral evidence of HM and JA helped him understanding their manner of speech, and it gave him assistance in understanding the context to the text messaging. So this was all a very good example of how you have to consider everything, including the context, the way people communicate. Extremely important to not jump to conclusions on this.
The format of the communications, and the fact that there are probably other communications. I mean, we were just looking at a case today that we're dealing with where there's like text messages, Snapchats, actual phone conversations. Like there's multiple forms of communication going on simultaneously.
And he, like you say, in these messages, he clearly goes after her about cheating. She clearly accuses him of rape in the text messages. It may be reasonable to expect that he would have responded in some way to the rape allegations. But as you go on and you look at this, the judge actually does find that there is a form of response that is somewhat of a denial. But in none of the messages does HM give any details of the alleged rape. And so there's a lot of complication, a lot of nuance as to how you read this. And there's just like tons of stuff back and forth. But, she clearly says stuff, I can't believe you would rape me. He responds, it wasn't even like that. She immediately texts, yes, you raped me. And so you're saying you didn't? Jay responds, I'm saying that it's not like how you're narrating it, like the way you're saying it, making it seem way worse than it was. Because I had no bad intentions. I would never intentionally want to make you feel pain. He's responding to the pain aspect and does not say, I did not rape you, but his text is responsive to her allegations and at least equally consistent with his version of events. In addition, his exchange indicates that even HM interpreted Jay-Z's response as a denial of rape. That's great because, so you're saying you didn't rape me? The devil's in the details and there's nuances and you've got to look at all this. I thought this judge did it because it was difficult to go through it, did a very good job of breaking down and understanding who these people were and how they communicated with each other.
And it says directly, the judge, at paragraph 80, I do not intend in these reasons to review all the June 9th and 10th text messages, but I've read through the text chain several times and have reviewed and considered the evidence of HM and JA about the text messages. And, you know, that's the thing, is like all of these cases, the evidence is very specific to each trial. And it's so important to not just take, you know, certain paragraphs and say this means blah. Like, you have to understand the context of what the judge was grappling with.
Yeah, and look,
And this judge grappled.
no, but does a very good analysis. On all the evidence, I'm satisfied that HM and JA discussed the allegations of rape by telephone or in person, that he likely responded to those allegations with a denial. Considering the text messages in their entirety and the context of the circumstances surrounding the messages, as well as the words used in the messages, it is not necessary for JA to respond to each and every allegation of rape in the text messages. He responds to many of them. Right.
Especially the speed with which they're exchanged sometimes.
Many of the messages from JA can be interpreted as a denial of the rape allegations, as a response to the facts as alleged by JA, and as an assertion that HM's allegations of rape are fabricated to counter an allegation of cheating. HM's own understanding, as reflected in some of the messages, is that JA denied the rape allegations in some of his texts. I find that there was no adoptive admission by JA of the allegations of rape by HM in the text messages. So, I'm sorry that we're reading a lot from it, but this is a really great analysis and a study of how to go about looking at and considering text messages and whether there is an adoption or admission of guilt. A very good case to read if you're interested in this, and I think it has excellent precedential value.
There's some further stuff at the end in the analysis, talking about some inconsistencies in the complainant's evidence and things that kind of tip the scales a little bit. In terms of, you know, it's important, again, to remind people that testimony is evidence, but a trial judge can accept all of, none of, or some of a complainant's testimony and an accused's testimony.
Yeah, you did that backwards. Usually instruction. You get some, all, or none.
Yeah, some, all, or none.
Yeah.
So you can accept completely what somebody says, but then still have some concerns about competing evidence. But you can also reject it completely, or you can accept some of it. And this is where we get into more complicated cases, where sometimes the complainant's evidence and the accused evidence can cobble together.
Yeah.
To say, I can't be sure what happened because I accept some of his evidence and some of her evidence. Well, they can reject some of the evidence. A rejection of some evidence doesn't mean you completely disbelieve them.
Yeah, and I like how in this case the judge did a very good analysis on motive to fabricate and reminds everybody of what the law is, because sometimes it's so easy to look over it. But, you know, there's a new case from the Court of Appeal, PM 2025 ONCA, paragraph 67. It's improper to impose a burden on the accused to show that a witness has a motive to fabricate. An absence of evidence of a motive to fabricate cannot be equated with a proven lack of motive to fabricate, because sometimes a witness's motives remain hidden, and it's improper to reason that the absence of a motive to fabricate conclusively establishes that a witness is telling the truth. You know, we've been through this area of law before, but I like when they do the reminders when they're considering it, and the issue of fabrication is but one aspect to consider, and they're duty-bound to consider it. And you don't have to prove it as an accused. But if it raises a reasonable doubt that in fact the complainant may have a motive to fabricate on your theory, that is a very powerful piece of evidence, and we've often spoke about that.
I just got distracted because I was reading this final paragraph at 129. I'm not going to get into it because it has to do with honest but mistaken belief.
Well, it's not. We've done that a few times.
I'm just like, that was an interesting comment. But anyways, like you said, this is for people who want to, are interested and want to go on 𝐂𝐿, this case is actually a really great one to see a lot of these principles being put into practice in a proper way. Hopefully. And
there's a bigger aspect to this. So
giving some clarity to the Supreme Court.
No, but this is where I think we need to be very careful too. And we're going to talk about this in probably another episode. Yeah. But, as we move along and we're dealing with some younger people with cases, texting is 90% of their communication modality, right? And we
Don't
have
use Snapchat, just to go back.
they will.
Oh, well.
But-
I don't want to say anything bad about Snapchat. I'm just saying it's not a perfect platform for preserving.
But if they want to become a
conversations.
sponsor, please do, and then we'll say nice things. But, you know, again, if we have 500 messages, 600, 700 messages, and they look like good, complete threads, you know, and we bring the application under Section 278 to admit this evidence, I want to just emphasize the importance of carefully analyzing the complainant side of text messages as well, because we see all too often disjointed, incomplete records of messages that completely rob it of context. Yeah. We often try extremely hard to make sure we've captured threads, we do extractions to make sure we get all the threads, the metadata, everything, so that there is no confusion about authenticity and about the accuracy of the context of which we're conveying. But I just want to say this. The Crowns may argue on motions that, you know, messages 1 through 59 are completely irrelevant. They're not, because they may be relevant as to how the two are communicating, so you can understand the other aspects of the messages.
The dynamic of the relationship.
It's so important.
Yeah.
And, you know, you're always met with arguments that it's not relevant. The dynamic's not relevant.
And we're always careful when we take out, because sometimes we'll have like thousands of pages of text messages. We're not going to put them all
Poor
into
Alper has to go
evidence,
through about 1,500
right?
in a case we have, right? Got to get it ready by Thursday. Hi, Alper.
So, you know, we don't, when we decide what things are relevant, we make sure that we include context. So you don't start with, you know, why are you yelling at me? Or something like that. Like we make sure that we get the lead into the conversation in that clip. And of course, we're not going to put in, we did at one point, go to put in thousands of pages. And they said, can you limit it down? And then we had to get more specific. But
no, but we
and
err.
I made a chart.
No, but we err on the side of more than less. And when you know, when somebody says, you know, judge goes like, this is a lot of stuff, I go, well, let's look at it this way. We can now pin down for you what we really want in evidence, but we want the entire record before you so that nobody makes an argument later on that somehow we skewed the context.
Yeah, I know.
I don't want that argument, because that argument it's fabricated, he manipulated, that's a fake message, he's hiding other messages. You get, or it's completely irrelevant. We try really hard to make sure we get the entire thread with context.
Yeah, you know, to show that there's nothing eliminated and to show how it started, how the conversation
Because I can
started,
tell you,
and how it ended.
so many times we get messages from complainants, and now what's starting to happen more than ever with some of these very, very active complainants councils, where after we bring the application under 276 and 278, you get the stage 2 ruling, and then sure enough, the complainant has more messages. Sure enough, it happens, you know, with the assistance of complainants counsel. And not all do this. A lot of complainants counsel I have a tremendous amount of respect for, because they understand their role and they stay in their lane.
Yeah.
If you're simply communicating what the complainant says, oh, I have extra messages, I would much rather see that play out during the course of the actual hearing, because it's not like we serve it with 7 days notice. We serve it what?
3 months in advance.
Right. So there's plenty of
Recently,
time.
more than 3 months.
There's plenty of time. Yeah, 4 months. There's plenty of time. But this needs to be changed. This notice requirement, I think, needs to be changed. There needs to be some amendment here. I don't want to see this continue. And this is why I think this case is really great. Judge admitted there was tons of evidence, went through it in detail. It really helped with context. And I don't want to see snippets of evidence come in later. And that's what we're seeing now, holding back evidence and giving it after the ruling on stage 2.
And what's changed, and it's still not in practice because it's so new, the Kinnamore decision, where the Crown is being told...
We're starting to see them now, though.
Yeah, we're starting to see them, but they're still a little bit slow because it's new, and I don't blame them for that, because it's kind of unfamiliar territory. And we file 3 months in advance. We don't have to. We're only required technically to file 7 days in advance. Right. We just like to give lots of notice.
And it helps with my obsessive compulsive disorder. Because if I didn't file that ahead of time,
mine too. I
would be on loads of medication.
I'm not a last minute person. But, you know, technically with Kinnamore, they're saying that ideally the Crown should advise us in advance what evidence they intend to lead so that we know how to respond to it. but we always file so much earlier, and then the Crown is trying to play catch up. And it's not their fault when a complainant suddenly dumps a whole bunch of documents on them after they hear our application. It's not their fault.
I don't know why they pick 7 days. You know, when you bring a charter motion, it's got to be 30 days. I think this should be at least a minimum 30 days before trial, and then on stage 2, there should be a requirement that there has to be a response time by complainants counsel, because they need to. There needs to be some amendments on these timelines, because frankly, there needs to be an obligation to be duly diligent and upfront about what other messages you may have that you failed to disclose earlier. Because in all these cases, the complainant gives 30 messages. After stage 2 ruling, here's another 40 messages.
Well, what did we get? We got over 500 in one case.
Yeah. All right. I'll complain about that more.
I just want to say
time
logic
goes
and
on.
common sense. In Kinnamore, they said the Crown should bring their application 7 days in advance so that the defense can respond. But the defense has to give 7 days. So I'm sorry. How does that work?
There is no way.
that work?
There is no way you can get anything done properly within those time periods. If you're properly doing an application, you got to be serving at least 30 days ahead of time, where you've got your notice and your factum in, or as we do it, a combined document. It's got to be in, and I think the notice requirements have to be changed, because we're seeing it in certain cases. It plays havoc. We had to drop everything, assess what's going on, and fortunately, we're working with the Crown collaboratively to go, no, you're right. This is not admissible. This is not admissible. This is not admissible. But you might not always get that type of cooperation. This is now starting to be a problem.
We typically get responses from Crown and complainant counsel, 2 days before the hearing?
Yeah, but I mean, we have a couple now. One of them, they did a great job. They were giving us, she was ahead of it. Both of them were saying, I'm sorry, we're tied up in trials. We're going to try and get it to you. I said, don't worry, you can give it by this date. And then eventually they consented, but they were totally in contact, totally trying to work it out. We've had this in 2 cases recently, and kudos to the Crown and to complainants counsel on that one. But there are those who run rogue and don't stay in their fucking lane, and they are doing everything they can to get other evidence out of the complainant after fucking stage 2.
Yeah. And there's not a lot you can do about that, but there is something you guys can do.
No, there is something we can do about it. There needs to be amendments to these sections now.
That was a segue. You just cut me off. Okay, go ahead. Yeah, I'll do it again. Go ahead.
No.
There's not a lot we can do, but there's something you can do. That is, you can like, comment, subscribe, share this video. We do read your comments, and thank you for 𝐸ZDNS?
𝐸ZDNS.
Yeah.
𝐸ZDNS.
𝐸ZDNS.
Yes,
if you want to make your tours on the internet safe, that's the place to go.
You can host your website with them. They're very secure, and it's a great platform. So thank you, 𝐸ZDNS, for your support of us. Thank you, everybody, for your viewership. This is episode 192. So we're coming up close to our 200th episode. Like, that's unbelievable.
I know. And if you want to hear the rant that I cut off from Joseph, tune in next week.
Yeah, I'll start off with the rant right away, I promise.
Right.
Good night. Thank you very much.